My name is Hakeem Olajide Bello, and I'm of the Department of Public Law, Faculty of Law, University of Lagos. This presentation, short presentation, is going to be on the offense of unlawful enrichment. This is one of the new offenses that has entered into the Nigerian criminal law recently as a tool for fighting corruption. And the reason is that in most instances, the prosecuting authorities may not be able to establish convincingly that an offender found in possession of substantial wealth has abused his office by either committing the offense of bribery or any other fraud or other related offenses. But the situation is such that the public officer is found in possession of such an amount of wealth that cannot be related to his lawful remuneration while he was a public officer. So the offense provides a way for the state to be able to establish that a former public official who was found in possession of substantial resources that he cannot reasonably account for should forfeit the resources to the state and be convicted of an offense known as unlawful enrichment or unjust enrichment. Like I said, this is a new provision that has entered the Nigerian criminal law space through the provisions of the Criminal Law of Lagos 2011. And we also have provisions creating the offense in the Criminal Law of Edo State 2022. So we'll start by looking at the offense under Section 82 of the Criminal Law of Lagos State, which creates the offense of unlawful enrichment. This is the first legislation in Nigeria to create a specific offense of unlawful enrichment. Section 82 provides any public official who enriches himself so as to have a significant increase in his assets that he cannot reasonably explain the increase in relation to his income, retires, resigns, or is dismissed from service and cannot reasonably explain the increase in relation to his lawful income, or after leaving office begins to derive economic benefits from favors he had conferred on the third party or parties while in the office, commits a felony and is liable on conviction to imprisonment for 7 years. Now, we need to note that this provision does not require the prosecution to prove any specific corrupt practice or any economic and financial crimes before liability under the provision is established. So we're going to see what the prosecution is obliged to prove before liability can attach under this provision. The prosecution is required to prove the following. A, that the defendant is a public officer or a former public official. B, that he has enriched himself while in office by a significant increase in his assets that he cannot reasonably explain in relation to his lawful income. Or C, that after leaving office, he begins to derive economic benefits from favors he had conferred on a third party or parties while in the office. It is after the prosecution has adduced evidence to prove the above elements that the evidential burden shifts to the defendant to lead evidence to establish the lawful source of the income. So the prosecution, first of all, has to establish that the defendant is a public officer or a former public official, that the defendant has enriched himself while in office by a significant increase in his assets, that he cannot reasonably explain that increase in relation to his lawful income, or that after leaving office, he begins to derive economic benefits from favors he had conferred on a third party or parties while in the office. So after the prosecution has adduced evidence to prove the above elements, the evidential burden will then shift to the defendant to lead evidence to establish the lawful source of the income. Now, if a a public official, a civil servant, maybe a level 12 officer, whose total take-home pay in a month is not up to 300,000 naira, is found to be in possession of an amount in the sum of 50 million naira or 100 million naira. 50 million or 100 million naira has been traced to an account that bears his name. Now, in that scenario, there may be no specific evidence to show the kind of corrupt practice that the public official has been involved in to enable him amass the sum of 50 million or 100 million naira. But we all know that his salary per month is less than 300,000 naira. So over a period of a year, his salary is not up to 5 million. So where on earth did he come to be in possession of 50 million or 100 million naira? So in that kind of a situation, what EFCC will do is to charge him for an offense under this provision. And all they need to prove is that the defendant is a public official or had been a former public official, and that while he was in office, he came into a possession of a significant increase in financial resources that cannot be related to his lawful income. His lawful income in this instance is a sum of 300,000 naira per month. So how did he come into the possession of the sum of 50 million or 100 million? Now, if the prosecution is able to establish these basic facts, then an evidential body now shifts to the defendant to lead evidence to show the lawful source of the income. For instance, if the defendant had won a lottery in the sum of 55 million naira, and the amount, the lottery sum was paid into his account, and he has spent 5 million, leaving a sum of 50 million, which EFCC traced to his account. That is a reasonable explanation to explain how he had come into possessing the sum of 50 million naira. And if he's able to do that, then he has not committed an offense under the provision of this section. Okay? But if he's not able to offer a reasonable explanation as to how he came into possession of 50 million naira, then the prosecution, he will have failed to discharge that evidential body, and his failure to discharge that evidential body will now support the prosecution in establishing the fact that he has unlawfully enriched himself while in office. That he has unlawfully enriched himself while in office. Now, the emergence of the offense of unlawful enrichment as a tool for fighting corruption has, however, raised concerns that the offense implicates the rights of the defendant to presumption of innocence. Now, we know that a defendant has a constitutional right to presumption of innocence. But like all rights, we know that that right is also not absolute. A response to such concern is that the right to presumption of innocence, like most other rights, is not absolute. And the issue had come before the European Court of Human Rights in the case of Salabiakou against France. The judgment was delivered in 1988. In Salabiakou versus France, the European Court of Human Rights recognized that some limitations may be placed on the right to presumption of innocence under domestic law. The right to presumption of innocence is limited in Nigeria to the extent that it does not invalidate any law that imposes upon any person the burden of proving particular facts. See Section 36, subsection 5 of the Constitution. Yes, every defendant has a right to presumption of innocence. But that right does not invalidate any law that imposes upon any person the burden of proving particular facts. Now, in this instance, this offense of unlawful enrichment imposes a burden on the defendant to show to the court how he had lawfully acquired the resources that has been found in his possession. And like I explained earlier, if he's able to offer a reasonable explanation as to how he came about the resources, then the prosecution will have failed to establish this offense. Section 140 of the Evidence Act 2011 puts on a person the burden of proving a fact when the fact is especially within his knowledge. Now, if in this instance, in the example I gave, a public official is charged with unlawful enrichment for being in possession of 50 million naira, when, like I said earlier, his lawful remuneration per month is not up to 300,000 naira. So this provision of the Evidence Act puts on that public official the burden of proving the fact of how he came to acquire the sum of 50 million naira. And if he's able to do so, then he will not have committed an offense under Section 82 of the Criminal Law of Lagos. In the case of Attorney General versus Hui King Hong, that is a decision in Hong Kong interpreting Section 10 of the Prevention of Bribery Ordinance. Now, Section 10 of the Prevention of Bribery Ordinance is like Section 82 of the Criminal Law of Lagos. The court considered and rejected the argument that Section 10 violated the presumption of innocence by placing a burden on the defendant to give a satisfactory explanation as to the source of wealth. So the court held that Section 10, which is similar to Section 82 of the Criminal Law of Lagos, does not violate the presumption of innocence. The court held that the provision requires the prosecution to prove the following beyond reasonable doubt. So the ordinary burden on the prosecution to prove the guilt of the defendant is still there. So the prosecution has to prove the following beyond reasonable doubt. One, the defendant's status as a crown servant, in other words, as a public servant. Two, proof of the standard of living maintained by the defendant during the charge period. Three, the defendant's total official emolument during that period. And finally, that the standard of living is above that which is commensurate with the total emoluments. The court noted that it is only after the prosecution has satisfied the above requirements that the defendant is obliged to prove on a balance of probabilities the existence of any capital or income independent of his or official emoluments, which will show the difference between his or her standard of living. So what the court is saying is that after the prosecution has proved 1, 2, 3, 4 above, then the defendant will now be obliged to prove how he had come into possession of the income. And if he's able to offer a reasonable explanation, like in the example I gave earlier, if he had won a lottery or he inherited, he has come into a huge inheritance from a very wealthy man that he had served in the past, then that will offer a reasonable explanation as to how he came into possession of the resources, and he will not have committed an offense under Section 82. In Dauda versus Federal Republic of Nigeria, 2018 10 Nigerian Written Law Report, part 1626 at page 169, the Supreme Court sustained the constitutional validity of Section 19(5) of the EFCC Act and Section 19 sub 3 of the Money Laundering Act 2003. Now, what these provisions in the EFCC Act and the Money Laundering Act provides for is that it allows evidence to be given at trial for offenses under the Act that the defendant has wealth for which he cannot satisfactorily account and which is disproportionate to his known sources of income as corroboration of the testimony of any witness. What those provisions are trying to do is this. If a defendant has been charged for an offense under the FCC Act or any offense under the Money Laundering Act, the prosecution is allowed to give evidence at the trial to show that the defendant was found in possession of wealth that he cannot account for. So if you are charged with an economic and financial crimes, and the FCC is able to give evidence that they found an amount in your possession that you cannot account for, what the court is saying is that, this provision is saying is that that fact can be relied upon as a corroboration of the testimony of any witness relating to the charge that is before the court, to corroborate the fact that you actually committed either the economic and financial crimes under the FCC Act or any offense under the Money Laundering Act. Okay? Now, this provision is different from Section 82 because it makes the inability to explain wealth an offense when the other ingredients of the offense explained earlier has been established by the prosecution. Section 82 is different. Section 82 is not providing a means of evidence to prove any offense under the FCC Act or under the Money Laundering Act. Section 82 is creating a substantive offense where you are found to be in possession of a wealth that you cannot account for as a public official or as a former public official, and you are not able to account for how you acquired that resources, you will have committed an offense under Section 82. That is different from what Section 19.5 of the FCC Act and Section 19.3 of the Money Laundering Act, considered in Dauda and Federal Republic of Nigeria, is saying. Those provisions only enable the prosecution to give evidence of the fact that, yes, we charged him for an offense under the FCC Act, we charged him for an offense under the Money Laundering Act, and we found a substantial amount of money that he cannot account for in his possession. So they are allowed under these provisions to give evidence of the wealth in your possession to corroborate the testimony of any witness that you had committed an offense under the EFCC Act or under the Money Laundering Act. But Section 82 of the Criminal Law of Lagos is different. It creates a substantive offense of unlawful enrichment. Once you have been found to be in possession of substantial wealth and you cannot reasonably account for the source of that wealth, the Lagos provision derives its inspiration from Article 1 of the African Union Convention on Preventing and Combating Corruption and Article 20 of the United Nations Convention Against Corruption, which obliges state parties to create the offense of unjust enrichment. So the Lagos provision derives its inspiration from these two international conventions. The inclusion of the offense of illicit enrichment in both conventions is informed by the fact that corruption is a clandestine offense, and direct evidence of the offense is usually hard to get, but it is often manifested in the immense wealth of a public official. You see, most times, it is difficult to prove which particular corrupt act a public officer has committed. It is difficult to prove whether he has committed the offense of bribery. It is difficult to prove whether he has committed the offense of extortion. It is difficult to prove whether he has committed corrupt practices under the provisions of the Public Procurement Act or Public Procurement Law. But what the prosecution may be able to prove is that, look, we found in his possession substantial amount of resources that he cannot account for. So if you have money and you cannot account for the money, then it is reasonable to assume that you illegally acquired the money. So this provision makes the job of the prosecution in establishing corrupt practices very easy. And now the public official or the former public official is now found guilty of a substantive offense of unlawful enrichment. So the offense of bribery usually involves two parties voluntarily consenting to the offense, and there are usually no concrete victims. You know, bribery occurs in secrecy. So how will you be able to prove that a public official has been bribed when the person who gave him the bribe is not complaining? But once you find substantial amount of money in his possession and he cannot explain how he came into possession of that money, that is sufficient enough to try him for an offense under Section 82. And the prosecution does not have to prove that he committed bribery, he committed extortion, he committed procurement fraud, or he committed other forms of embezzlement. No. So the offense is designed to overcome the challenges of gathering evidence to establish corruption, where a public official's wealth cannot reasonably be explained in relation to his or her lawful income. Note that under Section 89 of Edo State Criminal Law 2022 and Section 140 of the Anambra State Criminal Law Draft Bill 2021, the scope of the offense has been expanded to cover non-public officers as follows. Any person who owns or is in possession of wealth or property, the source of which the owner or person in possession cannot reasonably explain in relation to lawful income or means, commits a felony and is liable on conviction to imprisonment for 7 years. Now, what the expansion under Section 89 of the Edo State Criminal Law 2022 and Section 140 of the Anambra State Criminal Law Draft Bill 2021 has done is to expand the scope of the offense to cover non-public officers as follows. Now, you can see the provisions there. So the idea here is that the offense now under the Edo State Criminal Law is not limited only to public officers. It's not. If you are a private individual and you are working in a company and your salary is 250,000 naira per month, and EFCC is able to trace 500 million naira into your account, and they ask you, brother, tell us how you acquired 500 million naira. Did you win a lottery? Did you come into inheritance? Did Bill Gates leave an inheritance for you in America and suddenly you converted the money to naira and now you have 500 million naira? If you are able to offer a reasonable explanation as a private citizen, how you came into, to be in possession of such an amount of wealth, then you have not committed an offense. But as a private citizen, if you are not able to account, for the resources, then you can be liable for the offense of unlawful enrichment, even though you are a private citizen. Even if you use human being to do otoromoko, you use human being to do juju, and the human being you used to juju has yielded hundreds of had yielded 500 million naira in the place in your room at home where you use human being's blood to do juju, and EFCC comes to arrest you and they found 500 million naira cash in your possession, and you are not able to explain to us reasonably how you acquired the money, you will be convicted of the offense of unlawful enrichment under the law in Edo State 2022. The fact that you are not a public officer is of little moment. And what will happen is that after your conviction, the court will order that the amount be forfeited to the state. So all the money found in your possession will be forfeited and handed over to the state. So that's where we are stopping the lecture. I expect that you will take time to listen to it over and over again, so that by the time you come to class, you come prepared for any question that you may have. Thank you very much. God bless.